Good morning for everyone, and welcome to the Iowa Supreme Court's oral arguments. Before we start this morning, I would like to say just a few words about the manner in which we are proceeding. As you are all aware, COVID-19 pandemic has affected life in all sorts of ways, and it has definitely affected how the courts do business. The Iowa Supreme Court continues to work very hard, and we are issuing opinions. But out of concern for your health, as well as the health of the court and our staff, we have temporarily modified the way in which we conduct oral arguments. We are proceeding today by way of virtual arguments for the first time, actually, and we are glad to have this alternative available. Fortunately, the public will continue to have an opportunity to view oral arguments as well. We have a YouTube channel, which allows the public to watch oral arguments in real time. Our YouTube channel can be accessed through the Judicial Branch's website. Through this alternative, we continue to provide access to justice, as well as public access to our proceedings. Our staff has worked very hard to make this technology work smoothly. I know they've worked with you, the attorneys of this case, as well as members of our court. Inevitably, some glitches may arise. If so, we ask that you please be patient, and we will get through this together. With those preliminary remarks out of the way, let's proceed with today's schedule. The first case set for oral argument is State of Iowa versus Anthony Ernst. State of Iowa represented by Sloven. Anthony Ernst represented by Bradley Bender. The second case will be submitted without oral argument. State of Iowa versus Deonacy Smith Jr. I'd like to do a quick sound check before we begin the arguments. We'll start with Mr. Bender. You can hear me, and if you wouldn't mind turning your audio on, we'd like to hear you.
I'm here.
Thank you, and we can hear you fine, and you can mute again. And if each of you would mute while the other is speaking, then we'll make sure to minimize the background noise. Mr. Sloven, if we could do a sound check first, and then I'll give you the green light to begin.
Good morning.
Good morning, thank you, we can hear you. Now, the camera that says bailiff is going to switch to a camera, and it's actually the actual courtroom calendar. So you should be, or excuse me, clock. So you should be familiar with that, and that is what we will use to keep track of our time. If there are any problems, this is the universal sign for problems. Otherwise, and we will stop and try and get back on track. Mr. Sloven, or excuse me, Mr. Bender, you may begin. Oh no, yeah, it is Mr. Sloven first. Excuse me. Yeah, excuse me, yes.
Thank you, Your Honor, and may it please the court, counsel. Good morning, Louis Sloven on behalf of the state. Thank you very much for making these accommodations. I greatly appreciate that we can proceed with this argument under these circumstances. The reason we're here is because the Court of Appeals, in its opinion, treated a stacked inference as something qualitatively different, undermining the sufficiency of the evidence to prove elements of the offense. And what it called a stacked inference, it means one element of the crime, identity, proven by circumstantial evidence, undermining the sufficiency of proof of specific intent by circumstantial evidence. This is a problem. O'Connell, 1979, held that direct and circumstantial evidence are equally probative. This isn't to mean that every piece of circumstantial evidence has the same logical effect or impact as eyewitness testimony about something that a witness saw. It means that every piece of evidence has the logical force that arises from its interaction with the other facts in evidence. We don't draw a categorical distinction between direct and circumstantial evidence, as the Court of Appeals opinion did. And this isn't just about what's necessary to prove an element, it's also about the effect of proof of a fact by direct or circumstantial evidence. And what this means is if there's sufficient evidence that a jury could determine, could find beyond a reasonable doubt that identity is proven, then identity is proven. When we use circumstantial evidence to prove specific intent, which we almost always have to do, it's very rarely susceptible to proof by direct evidence, you don't return back and say, well, we're discounting the strength of some of the circumstantial evidence of specific intent because identity was also proven by circumstantial evidence. The effect of this, adopting this kind of framework, makes it very, very difficult to ever prove a burglary or attempted burglary. It will have it would have impacts on prosecutions for violent crimes that involve specific intent, including first-degree murder. And it's just inconsistent with Iowa case law about direct and circumstantial evidence and about review for sufficiency of the evidence, where we allow juries to make a determination to apply their common sense, their lived experiences, to determine which of competing inferences from circumstantial evidence are actually reasonable and which ones aren't consonant with their lived experience.
So there's a difference between stacking inferences based on the circumstantial evidence and then inferences themselves. And that's what I'd like to talk to you about, or like to hear from you about, doesn't this case allow an inference of intent to commit theft from evidence of the breaking and entering? Isn't allowing those inferences to be, isn't that really just collapsing the elements? So you're allowing evidence of attempt to enter the garage to then be used to infer the specific intent to commit theft while in the garage. Isn't that just collapsing those elements?
I don't think it's collapsing the elements, Your Honor. I think that the elements require a finding of proof beyond a reasonable doubt on each of those elements. Now, finding that he broke into the garage is extremely relevant and probative with regards to what was his specific intent. Woodruff 1929 contains an extensive survey of the then existing case law, and reiterated by this court in Irving, that in the vast majority of cases, it's just reasonable common sense that generally the intent that you would infer from a breaking and entering is the intent to commit larceny within. That there could be other intents associated with that based on the facts and circumstances in each individual case. But generally, the reason why a person would break into a house a populated house, like a residential area that, maybe a bedroom might be different. A garage is where the stuff is. So that's a circumstance, varies from case to case. Now, to your question about collapsing the elements.
So you said it varies from case to case. In this case, was there any evidence of what was inside that garage that would have caused him to want to enter that garage? So in Irving, there was evidence about there were pharmaceuticals that he was trying to get to.
Yeah, so the evidence, so this overlaps with some of the evidence connecting Mr. Ernst to Mr. Wolfenkuhl, is that Ernst's company, and this comes in through the testimony of Decker, Ernst's company employed Wolfenkuhl's employer as a subcontractor, and Wolfenkuhl around this time was assigned to some job sites working for the same company. And so Ernst would know so that forms the basis for the connection for Mr. Ernst to know to expect that he wouldn't be home, that Jason wouldn't be home. And then to know the kinds of things he might expect to find in the garage, including power tools, and a garage generally would be a place where you would keep property. I also want to say that when you're evaluating, I don't think it's problematic that the proof of one element of the offense is part of the circumstances from which you infer specific intent. We do that if you look at intimidation with a dangerous weapon or first-degree murder, you can draw an inference from the use of a dangerous weapon, an inference of malice aforethought, or an inference of specific intent to cause fear from the use of a weapon that fires the shots. It's part of the proof of one element, and it's also relevant circumstantial evidence that you use to make an inference of specific intent.
Mr. Sloven, this is Justice McDonald. My question for you is the nature of the relationship between the defendant and the homeowners, and I guess one of them was his probation officer, does that cut against the intent to commit larceny? So in other words, some of the cases talk about, we would assume the intent to commit larceny from the fact of entry alone, but maybe that inference is different where the parties have a relationship and maybe he was entering to vandalize or commit arson or do something punitive toward his probation officer. Can you address that?
Yeah, it could be different, Your Honor. And I want to emphasize that the fact of the entry is very strong circumstantial evidence. I think we already start in an area of it's strong circumstantial evidence of intent to commit larceny, regardless of any knowledge of particular items that might be on the inside. But you raise a valid point. There's evidence in the record, though, through the testimony of the parole officer, that their working relationship was very cordial. She had spoken to Mr. Ernst's sister. She recognized and had conversed with Mr. Ernst's mother. They had no acrimony in this relationship. There's no evidence of any of that. And in fact, that's part of why the court directed out, found no substantial evidence to support the alternative theory of assault. Now, if you mention arson, now we're in a tricky situation where the arguing that the alternative that creates reasonable doubt about whether he had a specific intent to commit a theft is maybe specific intent to commit arson, which is also a burglary. That's a very thorny issue that I have a lot of thoughts on that I don't think is implicated here, where it's an alternative that is another way of committing the crime that's being invoked as a defense to say, anyway, I don't think that's implicated here because there's just no evidence of any acrimonious relationship, of any intent to vandalize. And the intent to vandalize or intimidate is not consistent with his subsequent actions denying any involvement and not leaving a message. And it's for the jury to draw reasonable inferences, to determine which inferences from this evidence are reasonable. That from the evidence taken as a whole, it all seems to tell one reasonable story about he thought, based on what he knew, that nobody would be home and that there was an opportunity to commit theft of property. Then he opens the door, sees a truck that he didn't expect, and then leaves without taking anything. It makes sense within a universe of, applying common sense and lived experience that's uniquely within the jury's purview to apply.
Mr. Sloven, also, if I recall correctly, the jury asked a question during deliberations regarding specific intent.
That's right.
What implication does that have, if any, for your argument here?
Well, I think it means that we know that the jury's question was, do we need to find specific intent to commit a theft, or is intent to commit any crime sufficient? And the court's answer was, it must be specific intent to commit a theft. And then it gave the short definition of theft by taking. And I think that helps focus. That means we know that the jury knew the question that they were answering for that particular element. We know that the jury determined that they had no reasonable doubt that his intent in breaking into the garage was to commit a theft. Now, I think that one of the big problems I have with the Court of Appeals opinion is that it never identifies, nor in any briefing, I think, has there been identified another inference of what Mr. Ernst's intent was that would be reasonable. The original opinion said that the state has to disprove all other inferences, all other rational inferences. The existence of any other rational inference means that there's no proof beyond a reasonable doubt. That's not the standard. That was disavowed. That's not how we treat these cases, because direct and circumstantial evidence are equally probative, and to apply a different standard for proof by circumstantial evidence would violate that rule. The revised opinion still, it cites to Truesdell, which says if there are two or more reasonable inferences that can be drawn from a piece of evidence, then there's no proof beyond a reasonable doubt. I don't think that statement of law can possibly be correct either. And I don't think there are other reasonable inferences you could draw here. I think it's up to the jury to determine which inferences are reasonable. But we have cases all the time where there's multiple reasonable inferences that you could draw or that look reasonable, and it's for the jury to decide which is reasonable and which they accept. And the classic example of this is a justification defense. We know that you can't submit a justification defense unless there's substantial evidence in the record to support it, meaning that a rational fact finder could accept it as reasonable, which would include a subjective belief that reasonable use of force is necessary. But then you also have submission of the charge to which justification is a defense, and you don't submit that charge unless you have substantial evidence for each element, including the in specific intent to injure or kill or whatever the charge happens to be.
Mr. Sloven, I want to, okay, let's talk about whether or not, if there was another reasonable inference that could have been drawn. What if there was, I trying to think of what another one would be that would still allow the jury to have made the reasonable inference that it was for theft. But say Mr. Ernst, there was somehow some evidence that he claims that his probation officer told him to pick something up at her house, and she claims no, that wasn't the case. That's very different than what the facts are, because he's not, he's saying he wasn't even there. But if there was that evidence and then that conflicting testimony, does that get to the place where there are two reasonable inferences, and is the jury still the one that's allowed to make that inference beyond reasonable doubt?
I think that's correct, Your Honor. In that instance, I mean, I think we have an easier time understanding that, because that comes down to a credibility determination where there's different evidence and the jury gets to determine what they find credible. But that would be an oversimplification of the jury's role to say that's their only role, is determining which witnesses they find credible. They also get to determine which inferences from circumstantial evidence they find reasonable and consistent with their common sense and what they know about the world. And, I find it, it's interesting to me that cases like Irving and Woodruff say you don't need to do empirical research to know that, to make the statements that are being made in those cases, that generally a breaking and entering is done with intent to steal something within. And maybe that's different if you're breaking into a bedroom, but if you're breaking and entering into a place where things are kept, maybe a pharmacy or maybe a garage, you start from a place where the most reasonable inference as a default is that the intent is to steal something that is kept within. And there can be, the reasonableness of that default can vary based on the circumstantial evidence present, and it can be rebutted, or there can be other evidence that affects the reasonableness of that inference or establishes a different competing reasonable inference. And that's what circumstantial evidence is really about, is enhancing or diminishing the reasonableness of different inferences that can be drawn to explain the facts that have been shown. Whereas direct evidence is, if you believe this witness, you have, their testimony establishes a fact directly. Circumstantial evidence is, it establishes these facts from which here are the possible inferences that arise from that. And then other evidence enhances or diminishes the reasonableness of those inferences.
Counsel, Justice Waterman here. Are we seeing this stacking of inference in other Court of Appeals decisions that second guess jury verdicts? And is it important for our court to send a message about to fix that?
I don't have the case name. I know that I've had to send the petition for rehearing and the application for further review to at least one other attorney in our division. But I know that this has happened at least one other time. I can't think of it offhand. I see I'm out of time. If I can briefly finish the answer. Thank you. And once is more than we want. To have this pre-1979 standard of statement of the burden of proof and review of sufficiency of the evidence challenges sneaking its way back in with a sanitized post-1979 citation, it just creates instability and uncertainty in the area of the law. And it's just best if this court clearly reaffirms there's no difference between direct and circumstantial evidence, both with regards to the required level of proof, and with regards to the effect of that proof. And that's what we want here. Thank you.
Thank you, Mr. Sloven. I already noticed one glitch. I failed to have my bailiff call court to order. We will certainly have the bailiff adjourn. It's not quite perfect yet. Mr. Bender, you may respond.
May it please the court. Chief Justice Christensen, Associate Justices, and Mr. Sloven. Good morning. My name is Bradley Bender, and I represent Mr. Anthony Ernst in this action. Contrary to the state's presentation, the Court of Appeals was correct in its conclusions and its analysis in this case. This is not a case where the court applied a heightened scrutiny for the state. This is not a case where the Court of Appeals undermined prosecutions for specific intent. The court looked at the facts of this case, and if we just looked at the facts of this case, we can see why inferences are very important and why stacking inferences is problematic. the Court of Appeals, in its opinion, did provide the correct framework. It acknowledges that circumstantial evidence and direct evidence are equally probative, but then it also talked about the inferences. And I think this is where the state fails to to really articulate in their analysis here, is that inferences, and Mr. Ernst acknowledges that inferences are part of our case law. In fact, this court has identified specific inferences that may be drawn from general categories of evidence, which gives the jury an important focal point and tightens their analysis. But then when we look at the inferences, though, we must do more than create speculation. They must do more than create suspicion. They must do more than create conjecture, because they do not create fair inference of guilt.
Ed Mansfield.
And in this case, that's where we have.
Hi. We've said in a number of different opinions, I'm going to quote one of them, but we've said it multiple times, an intent to commit theft may be inferred from an actual breaking and entering of a building which contains things of value. Now, one can argue how valuable the contents of the garage were. I think it was the probation officer, the spouse, who testified that, or maybe the construction worker, they both testified that the items in there were probably not a whole lot of things that somebody who was stealing stuff, interested in stealing stuff, would be interested in. But nonetheless, why can't that inference that's in our law be applied here?
Well, I think in order to get to that inference, there's required more stacking in this case. And I think that's very important. I think that's why you have to go look at what was the evidence that was presented by the state in this case at trial. First, they do not put Mr. Ernst by any eyewitness on the parole officer's property. No one saw him go up to the garage. No one saw him on the property. No one saw him prying open the door or anything. So the first inference that has to be made, was he on their property? And the state tried to establish that through cell phone records and also through video from down the road, from the business that was down the road, to try to get him in the vicinity of the residence. But see, the problem is we have to start with one inference here, which is, was he on the property? Then we have to go for another inference, is, did he go up to the door and pry the door open? And the evidence does not establish. If you look at the exhibits that were admitted at trial, you see the door. Now, we don't have a photo of the door as it appeared when the husband came home that day. They had to reopen the door to try to show what it appeared like. But if you look at the door,
Mr. Bender, so I want to back you up to where you said that you're relying on the stacking of evidence and there's no direct evidence of seeing Mr. Ernst at the property or the one prying open the door. But once the jury makes the decision or bases its decision on the circumstantial evidence that his car was in that vicinity and he was driving it and there were no other cars that were unaccounted for on that road. Once they make that finding, isn't that then, how is that finding based on circumstantial evidence any different than a finding based on a direct eyewitness if someone had actually seen him in the driveway?
Well, that kind of will contradict what this court has long held in several cases, that mere presence at the scene of a crime is not enough to prove the defendant committed the offense. We need more. Just for the fact that he was in the general vicinity is not enough. So that's why we had to start stacking the inferences here in this case. And that's what happened in this case, is because the state did not have the direct proof in this case.
So Mr. Bender, it would not have been enough for someone to see him in the driveway. They had to actually see him prying open the door. Is that what you're trying to say?
No, what I'm trying to say, if they saw him on the property, because I think it was, I'm trying to remember which case that the Court of Appeals cited. In one of their cases that they cited, with respect to their idea that direct evidence of forced entry and committed with circumstantial unsupplanted intent One of those, the defendant was found to show that he actually committed, the break-in and entry and stuff. And
Mr. Bender, Mr. Bender, could I stop you? Mr. Bender, we're having a little bit of trouble with your audio. Yes. I don't know if you're streaming, but maybe if you could back up just a sentence or two. And try again.
Can you hear me now?
Yes, thank you.
Can you hear me now? You can hear me?
Yes, we can hear you.
Okay. I forgot what I was trying to say.
You were describing a case, one of the cases that the Court of Appeals cited.
Yeah. I'll just thought that with respect to that, they had eyewitnesses that placed if you look at the 4 cases that the Court of Appeals cited, they had eyewitnesses that placed the defendant within the vicinity, either on the property or near the property of these alleged instances. In this case, that's what we do not have in this case. And I think that's what the problem when we look at this here is that we have one inference of him being in the vicinity, which we know the court has said mere presence is not enough. So therefore, we have to go up to see, was there actually a prying of the door in this case? Was there forced entry, break-in and entry? And there's no evidence, only from the homeowners, the pro officer and her husband, that says they thought the door was shut. They came home and the door was open by a half inch to an inch.
Mr. Bender, this is Justice McConnell.
There's pry marks along
Mr.
the door.
Bender,
if you
can I ask
look
you a
at
question?
The door, to me, it's an older door. But to me, go ahead.
Mr. Bender, yes, Justice McDonald would like to ask you a question.
So it sounds like from your argument, you're really attacking the sufficiency of the evidence on identity and whether there was a break-in into the garage. Assuming both of those things are established, do you take issue with Justice Mansfield's question, which is that our case law says a jury can infer specific intent to commit theft from the mere fact of breaking, which I think is, at least for me, kind of the issue. And you've never really responded to that particular question. Do you contest that that's what our cases say and whether that's correct?
Okay, I do agree that under Irving, they do say that with respect to breaking and entry. I do agree with that. Under Woodruff, though, with respect to Woodruff, that's talking about breaking and entering at night. And that's where you can infer that there was attempt to commit larceny. That was under the old burglary statute that was in place at the time. And I think that's different than what we have here now, because we do not, this was not at night, this was in broad daylight with respect to that.
Yes,
but I do agree,
Counsel,
based on what
Counsel, what do you make of the fact that Mr. Ernst allegedly knew that there wouldn't be anybody home, or at least would have believed that there wouldn't be anybody home at that time?
With respect to that, that is just a speculation at the best, that, with respect to whether or not what Mr. Ernst knew, what he did not know. That's the position that Mr. Ernst is taking in this case. The state is speculating that Mr. Ernst knew that the husband would not be there, that the pro officer would not be there, that there would be items in the garage for him to go and get. But there's no evidence to show that, with respect to that it was Mr. Ernst, he had any animosity toward the pro officer, why he would even go over there. And I think the pro officer, even she testified that she had 55 other people with respect to who she was supervising. She never had any issues with Mr. Ernst. So to me, I think that's another speculation here that, we're speculating that he knew, possibly knew, but we don't really know what Mr. Ernst knew at the time, that day, so to speak. I am having a lag on the time video.
It shows
so,
about a little over 4 more minutes.
Okay. With respect to the rest of this case analysis here, I think what we need to look at is the fact that in order to get from Mr. Ernst's identity to Mr. Ernst's specific intent, it is one inference after another. And I do think that is the problematic framework that we have here, in the sense of, if we allow this conviction to stand, that means anybody who can be placed near a scene of a crime, and if you can make certain inferences, then he's automatically guilty. And there's nothing that a defendant can do. I know the state is worried about the fact that whether or not they can get prosecutions in the future, but the state, when we're allowing inference upon inference upon inference, and we do have, what everyone says, a breaking and entry, you can infer intent, with respect. The problem is, when you don't have that direct evidence and you're relying on circumstantial evidence, when you start stacking them, that's the problem that we have. That we should not allow a conviction to occur when everything is being speculated or everything is being under conjecture.
Counsel, I have a question. If we find there's enough evidence for the jury to place him at the scene, what is the innocent alternative inference to be drawn if he's the one at the garage for prying open the door?
Well, placing him just at the scene is not enough. Then we have to assume that he was the one who went up and opened the garage. Well, there's other inferences on the garage. The garage door could have been left open. They just may have thought it was closed. It could have been left open. The wind could have caused it open. An animal could have hit into it and caused it to open. If you look at the door is not a brand new door. It's an older door. So, there's a lot of inferences that could be drawn on how that door could have got open besides someone prying open the door. And, that's the problem. Just because someone's near a scene, and when there's no burglary.
What kind of animal could have left that damage on the door?
Well, to me, reviewing the exhibits, we see, I think there's 2 spots of old weather seal that was damaged. That's it. It's not a traditional pry mark where you see where, the whole lock is being pried open, or you see on the wood jamb, a whole bunch of marks where it looks like somebody have a crowbar. In this case, you don't see that.
I have a question for you, Mr. Bender. Mr. Bender, Mr. Bender, aren't you kind of saying that it's okay to use some inferences if they're to my client's advantage, such as maybe it was a wild animal? But when you start talking about some inferences that might point the finger at him, you're saying, no, you can't do that. Aren't you kind of telling us that we can do it sometimes and sometimes we can't?
Well, I'm trying to say that when there's more than one inference can be taken from one piece of evidence, this court has said then we need to make sure that, when there's more than one, we need to look at and see exactly what's going on here, because it's not a clear-cut inference that, the state is trying to make it sound. The state is, wants to make it that everything in this case is clear-cut, that it's Mr. Ernst who did this, was at the scene. He went and pried open the door because he wanted to go steal something inside their case. But actually, first they thought he was in there trying to assault her. That's what the first theory was. They had intent to assault. Then the court dismissed that, so they had relying on intent to commit theft. But in my understanding, Mr. Ernst's position is that when you have more than one inferences that can be given on one piece of evidence, then the inference that the state is trying to draw has to be more than just speculation. In this case, it just was mere speculation on each of these inferences.
Mr. Bender, okay, I was gonna say your time is up, but you had a little bit of a glitch there. If you'd like another 15, 20 seconds to wrap up, you may.
I was just gonna say, it's Mr. Ernst's position that you affirm the Court of Appeals decision in this case. Thank you.
Thank you.
I do apologize.
That's okay. We're all getting used to this for today, so thank you. Mr. Sloven, would you like to respond?
Yes, thank you, Your Honor. The I want to start with Woodruff. Mr. Bender's correct that Woodruff and a lot of the cases cited in Woodruff say breaking and entering at night, and then it will enable an inference that sustains proof beyond a reasonable doubt of intent to commit larceny, typically. A lot has changed since 1929. Human nature really hasn't changed a whole bunch. People still have a general motive for, for profit and personal gain that you can generally impute to most people when you have otherwise unexplained acts. One thing that has changed is that you have a lot more households where multiple, both people are gone during the day with their own individual careers. And Mr. Ernst here has particular knowledge that he would be, access to knowledge that both of the homeowners here would be gone during the day. So I think this helps illustrate the point that when you have a breaking and entering that is otherwise unexplained, you start with a natural inference that intent to commit larceny is the most probable, the most, a reasonable one from the get-go. There can be circumstances that impact the reasonableness of that inference, maybe raising alternative inferences or maybe diminishing the reasonableness of that inference, or they can enhance the reasonableness of that inference and defeat alternative inferences of specific intent. And in this one, Mr. Ernst would have access to knowledge to know that this house wouldn't, or to expect that this house wouldn't be occupied. And then upon breaking into the garage door, seeing the truck, that's why he leaves without stealing anything. All of the parts of the story enhance the reasonableness of that particular inference of specific intent.
Mr. Sloven.
Oh, go ahead, Justice Apple.
Well, I just want to ask kind of an analytical question, and it's this. The law is clear that at some point, evidence, direct or circumstantial, is too speculative to support a conviction. It's a little bit of a spectrum, I think, although I invite you to challenge that too. But I mean, one, some cases, the evidence is overwhelming, it's kind of clear, and then you kind of move down, and then there's enough to sustain a jury verdict. And then finally, you get to a place where our case law would say that it was just kind of too speculative. Now, I think that the classification between direct and indirect and so forth is not very helpful in that analysis, and that's part of your point. Some direct evidence can be extremely weak. An eyewitness identification is direct evidence, so it might be extremely weak, while circumstantial evidence might be strong. So the question does it fit in a box, circumstantial or direct? The question is it persuasive? And I think you agree with probably everything I've said so far. But the issue then is, how do we as an appellate court use tools to determine when the line has been crossed from substantial to speculative? There is a line, the law establishes it. Tell us how we do that, other than by kind of a totality of the circumstance, kind of somewhat unsatisfactory response. I think you understand what I'm
Yeah, and I think that is the real question. Now, totality of the circumstances, I think you do consider all the evidence, right? The one thing you don't do is substitute the appellate court's judgment for the finder of fact, for the jury's assessment of which of these explanations is the most reasonable and which of these alternative explanations is not reasonable.
Surely true, but we do say, I mean, and there's case law that says, well, and it's presented in the box of speculation. It says, well, yeah, there was some evidence here. I mean, there's suspicion all over the place, but mere suspicion ordinarily isn't enough. I mean, that's kind of a conclusory statement. But the fact that there are some facts linking some defendant to a crime is not enough. Other than using our best judgment, where are we?
I think that it's correct to say that you need more than the person's presence at the scene of the crime. You need some sort of evidence supporting an inference that they did the act. When it comes to specific intent, you're in it's a situation that's more susceptible to there's something happening in this person's head, in this person's intent, and which of the inferences is it reasonable that a jury could conclude that this was their intent, and could the jury decide that other competing inferences of intent are unreasonable? And I think that that is, I see my time's expired, if I could briefly finish the answer.
Yes, you may.
Thank you. I think that that determination is uniquely within the jury's common sense. And it's, you know, jurors from 1929 are going to have different common sense and different lived experiences than juries today. We expect jurors to apply that, their common sense, to determine which explanations about specific intent are reasonable and which ones aren't. I think the jury has a review of determinations, sufficiency of the evidence to support specific intent is going to, might be a little more, there might be less room to reject jury inferences about specific intent as speculative than you might have in other areas. But I still think the core inquiry is the same. I think the core inquiry is that once you prove identity, once you prove the fact of the breaking, whether or not you proved it by direct or circumstantial evidence, it's up to the jury to determine whether, you know, which of the inferences of specific intent are reasonable, which ones create reasonable doubt, and which ones aren't reasonable. And that's the core function of the jury that the appellate court shouldn't be assuming. Thank you.
Thank you. The case of State versus Anthony Ernst is now submitted to the court, as well as the case without oral argument, State versus Smith Jr. Bailiff, you may now adjourn court.
The Honorable Supreme Court of the State of Iowa is now adjourned.